My name is Jenny Falbert, and I'm the Editor-in-Chief of Career Education Review. I'd like to thank you all for joining us today for this important topic. I don't want to take up too much time, so I'll just keep it brief about Career Education Review. We have an 88-year history of providing information to the career education community. We publish twice a month and strive to be the source of news, best practices, ideas, and commentary for the sector. We cover a wide range of topics, including school operations, student retention, public policy, compliance, and curriculum development. When I recently took the position over in February, one of my goals for Career Education Review was to make it more accessible to a broader audience. So when Peter came to us and with the idea of doing a webinar series, we were thrilled to be able to work with Peter and his team on that. I think this gives us an opportunity to reach a new audience and is an added benefit for our current subscribers. So I would like to thank Peter and his team for their continued support of Career Education Review. Now, before we begin, I'm going to answer a couple questions. We will be recording the webinar, which will be available on both of our websites along with the PDF of the webinar. You will receive an email tomorrow with that information. Additionally, for our Career Education Review subscribers, Peter and Katherine will be writing an article on this webinar today, which will then be featured in the next, the July issue of Career Education Review. Now, if you have any technical issues during the webinar, please just send a message to the chat function, and I'll try to help you with your issue. Also, if you have any questions, please submit them through the question feature, and we'll save about 10 to 15 minutes at the end for questions. Finally, we hope you'll attend our next webinar on June 5th, which will be Managing Open Program Reviews, and we'll have a link to that in the follow-up email that you'll receive tomorrow. So without further ado, I'll go ahead and hand it over to Peter and Katherine to begin the webinar.
This is Peter Leyton, and I really am pleased to have you listening in on us. And as soon as we get I'm waiting for the button, Jenny. But okay, I think.
Now, Peter, if you just show your screen.
I thought I clicked the button. Is that it?
Yep.
You see it?
Yep, we're good.
Okay. I don't know if I was talking a few minutes ago. Again, let me just echo Jenny's comments and welcome you to this seminar. It's the second one we've done with Career Education Review. This one, as you know, is on state authorization, so we will attempt to talk about what we know and avoid speculation as much as possible. Obviously, these views are those of Katherine, Brodie, and I, and the information we are presenting is not legal or regulatory advice, so we do need to make that clear up front. What we're going to try and do in the next hour here is cover the regulation in terms of the one which was published, 34 CFR section 600.9 in July of 2011, and then also talk about the negotiated rulemaking process, which is ongoing right now, and which includes a portion dealing with state authorization and its relationship to distance education programs in schools, as well as foreign locations of domestic schools. And lastly, we're going to talk about the current status of the state reciprocity process, which is intended to make this process of obtaining state authorization easier, and referred to by SARA. Katherine and I will alternate throughout, so we'll be covering different sections of the presentation, and right now I'm going to turn it over to Katherine.
Great, thanks Peter, and good afternoon everybody. What I'm going to do is just take the next few slides to walk through the sort of laying the groundwork for the purpose and the interesting history of this rule since 2009. A lot of you are intimately familiar with that history, but I think it's important to set the framework for some of the things we're going to talk about today in terms of the underlying intent of the rule. And given that there is still so much in flux and change with regard especially to the distance education piece of this rule, it's a nice reminder of what the department is trying to achieve. So their purpose for initiating the initial rulemaking in 2009 was very clearly laid out in the October 2010 preamble to the final rule, and it really is focused on the fact that there is a concern at the Department of Education and the current administration that states have a very important role in the triad, the federal accreditor state triad of gatekeepers of the institutional eligibility standards for Title IV funding. But there was concern that some states, and in particular California, having delegated their role to accreditors or not engaging in their role actively enough to maintain a proper level of standard with regard to state oversight. As a result, the Department of Education believes there's a need to establish minimum requirements for state oversight. And there's been, in the comments that were filed with the rule and even through today, a fair amount of controversy about whether or not the federal government, the Department of Education, is engaged in an incursion on state authority in this area. I think it's fairly clear if you look at the D.C. Circuit opinion that we'll talk a little bit more about, and from the department's perspective, that they don't feel it's a state incursion because states are free to act or not act in a manner that would bring a school into compliance with the state authorization rule, and because of that flexibility on the state level, that it's not an incursion. So that's really the underlying purpose of the rule, to strengthen the state prong of the triad. Peter, can you advance to the next thing? Regarding the statutory basis, it's within the Higher Education Act, and it's simply the requirement that as a condition of participation in Title IV student financial aid programs, that an institution of higher education of any kind be legally authorized within a state to provide a program of education beyond secondary education. And even in the current rulemaking proceeding with regard to distance education, which we'll talk about, there is still much debate about whether this particular HEA provision is an adequate statutory basis. Nonetheless, it is the language on which the department hangs its hat with regard to the authorization and which the D.C. Circuit agreed with. A little bit about the legal history. The D.C. Circuit reversed the district court decision back in 2012 that the Association of Private Sector Colleges and Universities lacked standing to challenge the state authorization on ground regulation, and was able to reach the merits to determine that the department's state authorization rule did comply with the APA because it was based on the statutory authority that I just mentioned, and was also based on a reasoned decision-making process that was not arbitrary and capricious. And this is where you get to, again, the underlying purpose of the rule. Both the court and the department in its rationale cited to the California agency the prior California agency lapse of oversight and anecdotal evidence about school state shopping. The upshot of that decision with the on-ground portion of the state authorization rule is that the department has the authority to require these minimum standards under state law in order for institutions to be Title IV eligible. With regard to the distance education piece, the D.C. Circuit upheld the district court's decision to vacate that portion of the rule that would have provided authority to the department to establish authorization requirements for schools that offer distance education in states where they do not have a physical presence. In other words, for example, the state in which the student and not the institution is located. This is purely a procedural decision with regard to the fact that the DC Circuit had determined that the department did not provide enough notice through the rulemaking process that it was going to rulemake in this area, and the practical effect of the court decision has been for the department to reinitiate a new rulemaking, which is ongoing right now, to look at this portion of the rule again on distance education and to establish a rule that can sustain any type of court challenge. We'll be talking more later in the presentation about that negotiated rulemaking, but for your information, this is the vacated part of the distance education piece of the initial state authorization rule. What we want to note for the audience well, and I think a lot of institutions already know this for a fact, but it just bears repeating because it's very important. Despite the fact that the distance education piece of the rule was vacated by the courts, institutions are still, for Title IV purposes, required to comply fully with current state laws that are applicable to their institutions and to their Title IV eligible programs, including state laws applicable to distance or correspondence education. In other words, Title IV regulations require institutions to be in compliance with state law. And this is a rapidly changing area. Again, we'll discuss this in more detail later in the presentation. But the vacation of the federal rule does not mean anything with respect to what states can do to authorize and establish regulation with regard to any aspect of post-secondary education. And institutions are expected to know those state laws and comply with them. And also, there's an existing provision in federal regulation that requires an institutional accrediting agency to look at the status of a state legal authorization when looking at accreditation and pre-accreditation decisions for programs and institutions. It's important to bear that in mind so that there's no misunderstanding that state laws applicable to distance education don't apply to Title IV institutions currently. So basically what the decision has done is really invigorate, in many cases at the state level, an increased exercise of jurisdiction over non-resident schools that are providing educational services. We'll talk a little bit more later on about the specific grounds for exerting jurisdiction at the state level, so that if you haven't done an inventory of where you are providing educational services around the country and you need to look at some of the triggers you might be dealing with before you contact the state to get your answer, this is what has been occupying a lot of institutions' time, is determining how states are changing their laws, and we'll have some recommendations on where to go to get the latest information. It really has become a cost of doing business to know and monitor changes in state law that may affect your institutional obligations. And we'll talk a little bit about the NPRM on gainful employment and the certification rules as they apply to state law and the interconnection between that and state authorization as well. So there's a lot of complicating factors that require institutions to really stay on top of these issues.
So what we're going to do now in the next few slides is walk through the regulation itself in terms of its requirements, which has been in effect since July 1st, 2011, unless you're in a state which is working on revisions to come into compliance. There are really two different sections that we're going to talk about the most. The first part is 600.9A1 Romanet A and B. And in A, the department has indicated that an institution, whether it's public, private, nonprofit, or for-profit, established by name as an institution, an educational institution, by a state, through a means such as a charter, statute, or constitutional provision or other action, is authorized to operate educational programs beyond secondary education. So, you know, the question then is, does the institution possess that type of authorization to be established by name. If the institution does, then the institution may, in fact, be exempt from some state licensure requirements based on accreditation, what's often referred to as licensing by means of accreditation, or based on operation of at least 20 years. I should clarify that the exemption based on accreditation does not have to be in this category based on this what's referred to as licensing by means of accreditation, but it might be. The other portion of the second step as an alternative to if you're not established by name is for-profit institutions, the question being whether you're established by a state on the basis of an authorization to conduct business in the state, such as through general articles of incorporation. If the institution is established through that means, then it's not considered to be an institution established by name, and it has to demonstrate that it's in compliance with all the state approval and licensure requirements. Institution in that context has to be named, and you need to be able to demonstrate that that the institution is licensed to offer programs beyond secondary education. An institution in this category may not be exempt from state approval or licensure requirements based on accreditation or years in operation or a comparable exemption. This second step, or 600.9A1 Romanet 2, also applies to nonprofit institutions. Entities established for a charitable purpose are treated the same as entities established to conduct business, but not established by name as an educational institution under Romanet 1. So again, nonprofits in this category must be appropriately licensed by the state agency responsible for post-secondary education programs, and the licensure or approval needs to identify the institution by name and indicate that it is an entity which is authorized to offer programs beyond secondary education. And again, it is not an entity which can be exempt from state approval or licensure based on accreditation or years in operation. So these two categories of an institution which was formed as a business under typical state incorporation laws, or formed as a nonprofit, as a charitable organization, through a similar process as a for-profit entity or corporate entity, they are treated the same under this regulation. Now, in the Dear Colleague letter 12-13, the department indicated that an institution, whether it's public, private, nonprofit, or for-profit, which is established by name as an educational institution through a charter, statute, or constitutional provision or other action, can be established through articles of incorporation. And those articles need to identify the institution by name and identify its purpose as offering post-secondary education. So this answer to a question views articles in two different lights. I mean, you have articles which are filed to create an entity to conduct business, which includes education, and articles which are filed that specifically identify the institution by name and its purpose as being to offer post-secondary education. We're going to talk about this a little bit more, but this is a statement that the department has made, and certainly in any official context, it has not withdrawn or withdrawn this statement, though there are some indications that the department might not consider this to be something which can certainly readily happen. This slide really does go on to make that point. One of the questions that's been asked is whether an institution could be established by name by receiving a letter from a state entity naming the institution. The department has indicated that the action of recognizing the institution as one established by name under other action or otherwise has to be by the legal entity in the state which has authorization over the institution's existence. Now, in Dear Colleague Letter 13-20, which is the most recent Dear Colleague letter on the subject, one of the things addressed in that Dear Colleague letter was some definition of the words other action, which are in the regulation. And in this Dear Colleague letter, the department actually gave two examples of what might be considered other action. Remember, other action would allow the institution to qualify as an institution established by name, and therefore an institution which could be exempt from state regulation if the state authorizes that based on accreditation or operation or comparable action by the state. And the two examples are an agreement between the institution as a participant in a state grant program where its students receive state funds that are provided only to students attending post-secondary institutions, or an agreement between the in-state institution and a public post-secondary institution in the state, an articulation agreement for students to be able to transfer to that public post-secondary institution and receive credits at the post-secondary level for the coursework done at the institution. The department's going to want to see the articulation agreement and the credit transfer policy, and we believe that with respect to the credit transfer policy, the department may be looking for an agreement in which at least a majority of the credits would transfer to the public post-secondary institution. The regulation and some of the guidance has also made it clear that in looking at whether an institution is recognized to operate in the state and offer post-secondary education and be established under Romanet II with respect to conducting business or operating as a non-profitable charitable institution, there is a need for the state to show that it took an active role in approving or licensing the institution, and not simply accepting an application or a fee for issuance of a license. So these bullet points here do identify specific comments the department has made in addressing the definition of active role. There may be more definitional information which comes out of the current negotiated rulemaking process. There has been some discussion of that, but in this case here, the department has indicated that simply paying a fee to an agency is not sufficient active role. State approval for a GED program would not meet the requirement for state approval. There are situations where state agencies issue both secondary and post-secondary approvals for programs, and this is has been and I think is a problem in some states, and with respect to compliance with this regulation, if it's not apparent to the public that the institution has been authorized to provide post-secondary education programs. The Dear Colleague Letter 13-20 has provided some guidance with respect to what the department is looking for in terms of documentation. And as indicated before, it is critical, I think, that your state documentation show that the programs approved are post-secondary in nature. There are alternative ways of showing that if the documentation doesn't say that, such as the state agency you are dealing with is only authorized to resolve or approve applications from post-secondary institutions. Again, if the agency authorizes educational programs that might be the same or very similar at both secondary and post-secondary levels, it has to be clear to the public, supported by agency regulations and the licensure process, that the institution has been authorized to provide post-secondary educational programs. So in that case, you might be able to point to the fact that there are two different systems, there are different regulations for the secondary and the post-secondary process. As indicated before, there is a process in some states of licensure by means of accreditation. Two examples are in Florida and California. And what I think became clear from over the past year or so is that this process of licensure by means of accreditation is acceptable to the department as long as the state can demonstrate that the agency involved had an active role in licensing the institution, that it wasn't merely the fact that the institution provided the agency with evidence of accreditation. And so in the case of Florida, the department found that it did have an active role. It reviewed a number of documents supplied in response to the application, and though less in oversight than what an institution applying for licensure would go through if it wasn't relying upon accreditation. The issue of exemption is a complicated one. It's still one in which there is a lot of lack of clarity, I think. The department has been besieged really with a number of inquiries from institutions asking for confirmation as to their status, with arguments to the effect that they believe they are in compliance. And this has been, the department, as you know, is got its hands full with a lot of regulatory activity, and they have not been able to respond, I think, in a very timely fashion to a lot of these inquiries. So it's created some considerable uncertainty on the part of some institutions. The analysis to date seems to be very specific, case-by-case analysis. And we are, I think, in a position right now where all we can do is keep pushing on the department to respond, because there are some significant adverse consequences potentially to an institution which doesn't know that it is exempt, if in fact it believes that falls within the exemption under establishment by name as a for-profit institution or other action by an appropriate state agency. Katherine?
Great. Well, Peter touched on this issue a bit, but I just wanted to take this slide to talk a little bit more in depth about one of the more thorny areas of the implementation of the state authorization rule. And it has to do with the fact that whether you are categorized as an educational institution or a business or charitable entity, you have to be able to show that you're authorized to offer education beyond the secondary level, and it's been a particular issue with regard to some sectors in particular, like trucking and cosmetology and similar sectors, where historically the authorization has come through a board level or an entity at the state level that has responsibility, historically not just for post-secondary education, but for issuing license for particular occupational categories. It's required really a national audit of where states are with regard to the statutes that control the agencies, and in many cases is requiring amendment of agency regulations and in some cases legislation. So the National Association representing cosmetology schools has been very, very active on this, but the department has said that in many cases the state laws that regulate these boards are not adequate currently to meet the state authorization rule. So this is an area that's going to take quite some time to get into full compliance with the state authorization rule as written, and I think really one of the unintended complications that's resulted from the way that the rule is structured. Next, we want to make sure not to forget the very critical standalone component of the state authorization rule. So this is part of the rule that must be met in addition to the elements that Peter discussed, and it has to do with a complaint process. So under the state authorization rule, an institution is only legally authorized by a state if they have a process, if the state has a process to review and appropriately act on complaints concerning the institution, including enforcing applicable state laws. So that's the actual regulatory language. Again, this is a separate standalone requirement that even if you satisfy the elements of the other part of the definition, you must separately meet. So in terms of adding some color to what this actually means, the department has addressed this issue in a March 17th Dear Colleague letter. It has indicated that regarding a state complaint process, the department will only recognize a state's delegation of responsibility for handling complaints, where the state remains the final authority on adjudicating that complaint, such as through a state attorney general's office or a more specialized state entity, but that after considering the complaint, the state may refer it to another appropriate entity for final resolution. What this is really saying is the state cannot be relying on the complaint mechanism within an accrediting body as a mechanism to resolve complaints, and institutions cannot rely on their institutional complaint mechanisms, and states can't solely rely on that either. Now, the department has tried to maintain flexibility both in the preamble to the final rule and in their other guidance about how states, what the state complaint process can look like, but they have indicated that there has to be a meaningful review of complaints. With regard to any complaints for post-secondary education, there has to be a state entity that fully reviews that complaint and has the ability to act on it in a final manner, although delegation is appropriate if the state has meaningfully reviewed the complaint initially. This is another very important component of the rule, and it is in effect now. As we'll talk about in a minute, the previous provisions of the rule that we've discussed have been delayed in implementation, but this is the disclosure piece, the consumer disclosure piece of the state authorization rule that was upheld by the court. So this rule, just in my informal checking around various institutional websites about how folks are handling this, the implementation is quite spotty out there in terms of the information that institutions really need to be providing to students and prospective students. What institutions need to be providing now is information to students and prospective students that is contact information for filing complaints with the accreditor for the institution and with the state approval or licensing entity and with any other relevant state official or agency that would appropriately handle a student's complaint. And this can be fairly simple and straightforward for many institutions that have a simple jurisdictional reach, but where there are many locations and where distance education is involved, technically speaking, the institution is required now to provide consumer information to students no matter where they are with regard to the appropriate forum for those students to be filing complaints. So in terms of additional guidance, the department has stated that the information can be provided on a school website, and that's what a lot of schools are doing if it's prominent and accurate. Remember that the federal misrepresentation rule applies here with regard to any inaccuracies, and you may link to a third-party list or site. And I would just like to recommend one resource, although I can't vouch for its 100% accuracy, but on the State Higher Education Executive Officers Association website, www.sheeo.org, they maintain a comprehensive list of state complaint entities that a school could consider linking to, although again, it's going to be up to the institution to ensure that that information is accurate. So there's flexibility with respect to how the institution provides that complaint disclosure information, complaint form disclosure information, but it's important to look at whether you're doing that correctly under current law. I'll talk very briefly about the implementation timeline. In the final rule in October 2010, the department certainly understood that it was going to take some time for states to come into compliance with this rule, and so there was built into that final rule the ability to obtain an extension for 1 year or for 2 years. Now the way that that works is to receive an extension of the effective date of the rule for institutions in a state, it is the institution's obligation to obtain from the state an explanation of how a 1 year or a second year extension would permit the state to modify its procedures to comply with the amended rule. So technically speaking, as of July 1st, 2011, if there's any question that the state's regulations were not compliant with the state authorization rule at the federal level, the institution needed to have something on file to show the department that the state had indicated it was working towards compliance. Whether these documents are in files where they need to be is another question, but technically speaking, that's how the extension of the implementation date was structured. In an August 22nd, 2011 electronic announcement, the department did provide some additional detail with regard to those explanations, and again indicated that the institutions need to have obtained and maintained this document. And they did reiterate in this that it wasn't the department's role to act as an intermediary between the states and the institution to obtain this documentation. So it's been a difficult spot for schools to be in. It's put institutions under a lot of pressure to engage with states. And in looking at the recent negotiated rulemaking materials, one of the negotiated rulemakers indicated that states had received, one state in particular had received over 1,000 requests from schools to clarify the rules. So states are being inundated with requests, and institutions have the main obligation to make sure that they're moving towards, or encouraging states to move towards meeting the rules compliance obligations. So then on January 23rd, 2013, the department reminded institutions of their obligation to comply with the rule. And this was really in part addressed to the states, encouraging states to work with licensed institutions to meet the requirements of the rule. And then again in May 2013, the department offered an additional 1-year extension with the same documentation requirements. You need to be able to show that the state is working towards being in compliance by that July 1st, 2014 date. And that's where we stand now. There's an open question whether, I know Peter didn't want me to speculate, but there is an open question about whether there's going to be another extension or not, and we'll just have to wait and see. There is a lot of work yet to be done to bring states into compliance, so there's probably a good argument for another extension.
So one of the driving forces here, obviously, as think Katherine mentioned at the beginning, I mean, the state authorization is part of what has been referred to for many years as the triad, the three-legged stool for an institution to be able to participate in Title IV. So having state authorization to operate has always been part of the process. And when an institution does not meet the requirements to be authorized by a state or accredited by a recognized agency, then it actually loses, as we all know, Title IV eligibility. Now, that can come up as an issue to demonstrate to a third party in a number of contexts. Certification process, initial certification, recertification is probably viewed as the primary time in which this would have to be demonstrated. It could certainly come up in the context of a program review or an audit, change of ownership process where you go through the application process again. Accreditation reviews could raise the issue, and accrediting agencies do communicate with the Department of Education, or even complaints to the department, which could come from any number of sources resulting in an inquiry. The department at this point simply expects the institution to maintain evidence, the required or necessary evidence of approval in its files. The open question being, given the nature of this regulation, I think, and how much it changed what had been long-standing practices, is how will the department respond if a couple of years from now an institution is going through recertification and the regional office determines that the institution was not authorized since July 1st, 2011. That clearly raises the specter of some severe liabilities potentially. Implementation falls in other categories as well. There is the disclosure requirements under 34 CFR 668.43. The institution is required to make available upon request state authorization documents to students and prospective students. Part of the requirement to demonstrate that you are authorized to operate in the state encompasses, from the department's point of view, not just the central licensing agency that may exist, but other agencies in the state that you may need to deal with and have approvals from, depending on the nature of your programs, such as professional licensure requirements. So again, when you look at the requirements that you have to meet, you have to obviously have the basic institutional authorization, which might be necessary for more than one entity, as well as programmatic approvals in one or more states, which takes us to the gainful employment notice of proposed rulemaking, which requires that an institution ensure that it's in compliance with the state licensing requirements in the states in the metropolitan area where the institution is located, which could, in many cases, involve more than one state. This is in the notice of proposed rulemaking, as I indicated. We'll have to wait and see if that remains or changes between now and November 1st, when I would expect the final regulation to be issued. Well, the consequences of failure, if a state refuses to come into compliance, well, then all the institutions theoretically in that state would not be eligible for Title IV, and there are a lot of adverse consequences that would clearly flow from that. I think it's very hard to see that actually happening at this point, but it's a theoretical possibility. But I think the principal focus that institutions are making at this time is really on ensuring that they are in compliance with this regulation so that they are not at risk with respect to Title IV liabilities.
Okay, I'm going to talk now about the pending negotiated rulemaking on state authorization. The final session is next week, so it is still ongoing. They're going to be determining next week whether they can reach consensus on a wide variety of issues that are under consideration, but one of them is the distance education piece that seeks to bring back the vacated Section 600.9C that would require institutions to have state authorizations for distance education when providing courses to students in other states. It also addresses the authorization of foreign locations of U.S. institutions. Peter, can you skip 2 slides up? I'm moving pretty fast. So to 33, thanks. So I want to emphasize that what I have here in the slides is the latest draft of the rule that's under discussion as of the last April 2014 meeting. It's just a draft, and as I mentioned, is under consideration next week, and by no means is final. But it does give us some insight into how the team of negotiated rulemakers has tackled some of the issues that have arisen with the on-ground portion of the rule and addressed them quite differently than under the current on-ground rule. So the way that the rule is structured, an institution would be deemed to have legal authorization for distance education where it offers, it would first of all be required to get legal authorization for a state where it offers 50% or more of a post-secondary program through distance or correspondence education. This brings the rule in line to the on-ground rule. Again, this is in draft, but the idea is to make this consistent with the on-ground rule with respect to the 50% rule. But in order to be legally authorized, the program, the institution that offers 50% or more of a post-secondary program through distance or correspondence education to students in that state must have its authorization based on the fact that the state has a process to review and appropriately act in a timely manner on complaints concerning the institution, including enforcing applicable state law, and has final authority to resolve complaints and enforce applicable law. So that's very similar to the on-ground complaint prong, but a little bit amplified with respect to the language. And so that's the standalone piece. And in addition, the institution meets state requirements that it be approved or licensed by the state to offer post-secondary distance or correspondence education, including programs leading to a degree or certificate in that state, or alternatively, the institution is approved to offer post-secondary distance or correspondence education through a state-to-state agreement, or alternatively, as a third category, the institution is in a state that's participating in a state reciprocity agreement. So this provides 3 separate grounds for meeting the state authorization rule. It has raised questions, at least looking at the conversations among the negotiated rulemakers on the committee, about what happens if, for example, a state-to-state agreement folds, or an organization managing a reciprocity arrangement folds. In that case, the institution would need to be able to rely on one of these 3 options to maintain their state authorization. So the questions have arisen as to whether this really just forces institutions to seek a full state license anyway, until there's more certainty, at least, with regard to the longevity of state-to-state agreements and reciprocity agreements. But this is the draft, the way it's structured. It would recognize the considerable work that has been done to try to bring states online with reciprocity, which Peter will discuss in just a minute. Another aspect of this rule is it tackles the exemption issue, at least this draft. The way this is handled is the institution is not considered legally authorized to offer distance education for Title IV purposes if it's exempt from state approval solely based on accreditation, years in operation, or other comparable exemption, except if the state has an active process that examines the institution and its programs. Now, interestingly enough, in the March draft, there were some particular criteria that some of the rulemaking stakeholders wanted to put in the regs to indicate what is an active process, and that certainly would have been somewhat helpful from an institutional standpoint, trying to figure out if your state complies. The April draft took that out, but some of the criteria they were talking about to indicate active review by a state to review the exempted institution includes if the state would look to the institution's fiscal viability, its student refund policy, the list of programs the institution planned to establish, programs subject to licensure and certification in the state, estimated tuition and fees. These are sort of representative examples of what folks were putting out there as evidence of an active process. That's doesn't have any legal persuasiveness, but it was just interesting from the fact that there's really been an absence of information out there about what exactly is an appropriately active process for a state that provides an exemption. This draft also would include a grandfather clause for currently exempt institutions, which is definitely a different approach. In the preamble to the final rule of the on-ground rule, the department specifically rejected a grandfather clause, but for distance education, the proposal here is to have a grandfather clause for currently exempt institutions that have approval for distance education in certain states, in a state, and to allow them to continue to operate for students currently enrolled on or before June 30th, 2008, and allow those students to complete their program. In addition, it allows even a one-year extension beyond that date if a school is in a state that cannot come into compliance. So there's a significant added flexibility to the rule in terms of implementation. There's also a useful proposed minimum provision that deems the state authorization rule satisfied if the institution providing the distance education is providing education to less than 30 students in a state, and that number is determined based on students enrolled during the prior award year. So it tries to get at the burdensomeness of having to go through the state authorization process for distance education when you're really just enrolling a handful of students in the state. But I would caution that the department has also indicated that state laws control in this area. In other words, if a state is exerting jurisdiction over an institution that's providing distance education just to one student in the state, that law would control. But this tries to establish a basic minimum in the event that the state is not regulating a minimum number. This first provision has to do with, it's an important provision because what it says is, notwithstanding what is in this draft rule with respect to what meets the state authorization requirement for distance education, the institution must still meet the additional requirements for legal authorization in the state that the state may establish. So that goes back to my prior comment that stricter state laws with regard to distance education apply, and that an institution still must maintain compliance with state laws on distance education. Again, this is a draft. It may change, but this is the way it currently reads. This draft also would significantly expand the current consumer disclosure provisions under current law with regard to distance education. In the current draft, they would, for example, require person-to-person disclosure of a variety of complaint process information rather than just posting to a website. It would require an annual report. It would have some potentially significant expansion of consumer disclosures. It also provides that institutions providing 100% of distance education would need to demonstrate that they're legally authorized in their home state. And what this gets to is the institution doesn't need to separately establish that it's authorized to provide distance education in its home state. It just needs to be legally authorized under the state authorization rule. There is also a provision that requires notice to students when an institution loses state authorization to offer distance education. when a state, for example, withdraws from a reciprocity agreement. So again, this goes to more enhanced consumer disclosures that the students need to be immediately notified when there's any change to the institution's state authorization. This provision is also quite interesting in its draft form. It provides that an institution would not be considered legally authorized for programs in a state if the programs don't meet the programmatic institutional or educational requirements for graduates of those programs to receive certification or sit for a license or certification exam in a state, unless the institution provides or obtains from the student in that state before enrollment a written signed document where they acknowledge that the program in the state in which they're taking the course, that the requirements of the state would not be met by that program. So it doesn't prohibit the institution through distance education from providing the program completely. It just requires a written acknowledgement from the student in that state that they acknowledge that the program does not meet the state requirements for that particular occupation. And I think this really was is intended to try to reduce the burden on institutions providing distance programming, having to determine state by state what programs they can and cannot offer based on the particular requirements, just because there's a lot of uncertainty right now with regard to the occupational licensing requirements.
We are quickly running out of time, so I think we're going to probably move very quickly through what we have left. This next few slides, and I'm just going to skip through most of them, relate to what Katherine mentioned, the State Authorization Reciprocity Agreement. SARA is a shorthand process. This is something which has arisen as an activity, at least primarily, if not solely, because of the regulation that we've been talking about for the last hour, and the process that schools have been trying to navigate through distance education. And so the concept here is really an agreement among states on uniform definitions of physical presence, and which they offer reciprocity to institutions in other SARA states to allow them to advertise, offer distance education courses and programs, employ faculty and other employees in the state, and et cetera. And the purpose is to create some ease in the process, promote predictability based upon uniform state law, and ideally reduce the cost of compliance for the institution. Concept is that there would be uniform standards developed and managed by regional compact organizations in each of the states in the compact. There would need to be some legislation passed to enable the state to join SARA and bring the state statutes into line with uniform requirements. There may be an issue here, but some SARA states are still planning to require filing of documents and assessing fees, which may be something which continues beyond once this is fully in effect. And there are still a number of issues being worked out in this process, such as professional licensure issues. There are 4 SARA organizations right now. The WICHE in Midwestern, New England, and Southern. And, you know, the concept here, as I indicated a minute ago, is to allow institutions to be able to meet the requirements of a group of states through essentially one application and one process, and with the other states in that group recognizing the institution as an authorized institution in its state, even though that institution did not go through that state's specific process, which exists. This is interesting. And in 2013, WICHE did a survey among institutions and found that only 13% were participating so far in any type of reciprocal agreement with another state. 1/3 were choosing not to apply to every state for authorization, typically, I think, because of cost. And I've mentioned a few states where a number of institutions have avoided that. It's a combination, I shouldn't say. It's not just cost. It's really a combination, I think, of that, the extent of the regulatory regime, and the number of students that either had enrolled in that institution previously or that they anticipated. Catherine?
Peter, yeah, I think this PowerPoint is going to be available to folks later, so I suggest we go right to questions because we have a Q&A at the back, but we've provided our answers.
I think
so, Jenny,
right.
I'll just check with you and see if we have some questions.
I think you can go ahead and answer the questions that we received during registration.
Okay.
And then I'll ask 1 or 2 questions.
Okay, great. Well, we did receive a question about the strategy for using the State Attorney General for the complaint process in a state as part of the requirement in the State Authorization Rule that the state have an adequate complaint process. And basically our answer here is that according to the available guidance, the AG's office can indeed serve this purpose, but there needs to be a process in place at the AG's office that accepts, reviews, and acts on post-secondary education complaints. And those complaints are actually acted on and enforced. And so that's going to depend case by case on the state AG's office and how they manage complaints, whether they just refer them out or whether they actually take them, review them, and meaningfully look at them before they refer them on to another more appropriate state agency. So again, it's state by state, case by case, but there needs to be some level of meaningful review in that AG's office.
Well, case by case may be the answer to more than one question. The second question was how an institution should handle state authorization requirements for out-of-state clinical placements, such as nursing students. And there is no answer here, I think, other than to say that you really do need to check with the applicable state or states to understand how they would handle it. And I would say the answer should be something which you document and can put in your files to show that, even if it's to the extent that the state says, well, we don't regulate that, that is something you would want to have in your file.
The third question has to do with whether the state authorization rule would apply where a school has just one student in a particular state. And the department has answered that yes, this institution still has to obtain state authorization. But as I mentioned with respect to distance education, the pending negotiated rulemaking draft rule would have a minimum. But again, if the state law has a minimum that doesn't recognize, a de minimis trigger, you'd have to comply with state law.
Another question we received was whether state authorization is required for locations where an institution offers less than 50% of a program, a Title IV eligible program. And the answer is no. I mean, the department's regulation does apply to institutions and locations that are Title IV eligible, so if it's less than 50%, they're not. But you would still need to ensure that you are in compliance with state law for that location.
Okay, the fifth question was what happens if the California BPP agency, the education agency legislation, sunsets again and it effectively becomes ineffective? I guess this depends on whether or not the state authorization rule is being actively enforced, but in the preamble to the final rule, it's clear that the department is implementing the state authorization rule for the particular purpose of preventing states from getting into this situation. So I think the threat of the loss of Title IV to students within a state that didn't have a meaningfully active state oversight regime should at least spur the legislature to avoid the situation in the future. And I think that would be the case. I think there would be probably greater efforts to try to bring that agency, make it not occur at all, or to bring that agency back online very quickly.
Yeah, the next question was what type of penalties could states impose for not being authorized? And I think some of the clear possibilities are a cease and desist letter from the state to the institution if it's not meeting what the state's requirements. A fine proposal is certainly conceivable. Obviously, you need to look at each state's statutes in this regard to see what they identify as possible penalties. Depending on how this has been handled, though, I mean, if this was a situation where an institution had represented to students and prospective students that it was authorized by that state to operate, there may well be further actions that could be taken against the institution or its ownership by the State Attorney General.
And the last question, sort of a million-dollar question, which states are currently not in compliance with the state authorization rule and have not contacted the department for resolution? Well, I think in this case there's been a misperception that states are actively contacting the department. Again, it's been the institutions that have really acted as an intermediary to press the states and the department for resolution. So institutions really do need to facilitate the answer. The department has specifically said it will not put out a list of states that are or are not in compliance. I would refer you, though, to the SHIO website again, because they do maintain a list of the states and what they currently require based on the state authorization and distance education piece of their laws. I can't vouch for its 100% accuracy, but it's a very comprehensive list. And it's, again, really up to entities outside of the department to determine that right now. And I doubt that the department's going to change their position on releasing any type of list.
Well, with that, I think you just answered the first question, which is there a list of states that do meet the complaint process? And I think you recommended the CHIA website. Could you give us the URL of that website again?
Yeah, it's www.sheeo.org, I believe, or .com.org. The State Higher Education Executive Officers Group, just SHEO.
Organization, yeah.
Yeah.
SHEOO.
Yeah, and they do have.
We can send that out to everyone also.
Right. Yeah, they have a list of the current complaint entities within each and every state.
Okay, and the next question, would all colleges have to apply to the respective SARA and then be accepted?
Say that again, with all what?
Would all colleges have to apply to the respective SARA and then be accepted?
Well, that does. That's most likely the case. I don't think it's clear yet. All states have not passed legislation to indicate what the process would be. We're talking, to be clear, I mean, this is with respect to distance education, not to the states in which you have an institution has a physical location. I certainly could envision a situation where schools would not have to use SARA and could use an individual state's process and with no interest in being authorized in neighboring states.
It looks like we just have one more question here. Would a subject matter expert who developed curriculum but did not interact with students be considered a presence?
Well,
yeah, that's totally going to depend on the state.
That's state, yeah. When you look at the factors that a state will use or examine to determine whether there's physical presence, we have seen just an extremely wide variety of factors. So in some states that